Okay, folks, we are now going to talk about the case of Roe v. Wade itself. Um, we are still in week 5 material, note 5 material. There is a specific note where I have provided excerpts from the case itself so you can see some of the actual language that was used by the court, used by the judges in the case. A little bit of history about Roe v. Wade. Um, Roe v. Wade was decided in 1973. Prior to Roe v. Wade, if you went back into the early part of the 20th century, most states had laws that made the performing of an abortion, the attempt to obtain an abortion, or the obtaining of an abortion illegal. In many cases, such activity was a felony and could result in a jail sentence of over a year. This had begun to change by 1973. Beginning in the early 1960s, the sexual revolution came into play, women's rights movement came into play in popular culture, and by 1973, these things were affecting the law. By 1973, a number of states, New York being one of them, and a number of the other more liberal states, had changed their laws so that abortion had become legal, at least under certain circumstances, maybe not in all situations, and maybe not as freely as it is today. But there was a movement towards making abortion legal, and that seemed to be growing. That seemed to be the way in which society was moving, and the state legislatures seemed to be following society's direction. Now, up until this point in time, this had not been a federal issue. Abortion was seen as a medical procedure. It was seen to come under the control of the states in their ability to use their police powers to regulate things that concern the health, safety, welfare, education of their peoples. So prior to Roe v. Wade, there was very little federal litigation or very little federal, almost no federal statutory framework dealing with the idea of abortion. It was something that had been, like divorce and education up to that time, had been left totally up to the hands of the states. The basic issue in Roe v. Wade is whether a constitutional right exists for a woman to obtain an abortion, for a doctor to perform an abortion without being prohibited from doing so or by the state without such activity being criminalized by the state. The theory upon which the plaintiffs in the case base their claim that there was a constitutional right to an abortion is tied in with the right to privacy, which we had spoken about in the last couple of videos here and we had begun to speak about in class over the last week or so. Um, Up to this point, the court had taken steps to make the availability of contraceptives legal. They had taken steps to throw out miscegenation laws that prevented marriage between people of different races. So they had begun to move in a direction stating that sexual activity and married life and conception of children, certainly education of children, those cases that come about in the early 1940s and 50s, were all coming under the court scrutiny, and they were examining the constitutional aspects of these various things. Now, as we had said in our previous lecture, it's very interesting because the right to privacy does not appear anywhere in the Constitution at all. The word privacy does not appear in the Constitution or its amendments. However, there are certain things like the Fourth Amendment, like the Third Amendment, that would tend to point us in the direction of a right to privacy. And there were some various rules and regulations and holdings in common law and English statutory law that seem to indicate that privacy could be a concern. But the issue really only grew in the early to middle 20th centuries. And with Roe v. Wade, we see it coming into full bloom and being the primary basis for a claim that a state cannot interfere in what the plaintiffs in the case framed as the doctor-patient relationship. That when a woman seeks to obtain an abortion, she is seeking medical advice about a medical procedure, and that without some compelling state interest, the state has no ability to interfere with somebody seeking medical treatment and determining what treatment should be available to them and not available to them. It's kind of an interesting argument because, without going into extraneous things that we could spend weeks, if not months, on, the medical profession is one of the most highly regulated professions in the country. The development of drugs is controlled by the Food and Drug Administration. The development of devices and different types of medical procedures are all controlled. The licensing of doctors is heavily regulated and controlled. So it's kind of an interesting idea that the lawyers in this case decided to pin their claims on the right to privacy, and particularly on the privacy between a patient and client. Up to this point in time, almost all of the right to privacy cases that had been decided by the court had to do with privacy within the family circle, privacy within the relationship of a husband and wife, or between the relationship between two consenting adults, and with the idea that in terms of sexuality and in family life, there were certain areas that should not be controlled by the states, and that were left to the private decisions of the individuals involved. So, in looking at this, even the court had issues, and even the court had questions, and it was not an easily decided case. And if you look at the handout that has the excerpts in it, the court itself goes to great length. They say that they find the right of personal privacy and certain zones of privacy in our lives, basically meaning there are certain areas that were kind of surrounded by an area into which the government should not be able to come without our permission, that they have to look to the First Amendment, the Fourth Amendment, the Fifth Amendment, the Bill of Rights, the Ninth Amendment, the 14th Amendment. So they're really pulling at straws here to pull this idea together, to give it some kind of firm basis, because again, it does not appear in writing in the Constitution itself. And the way that we look at privacy today is a concept that was probably fairly unknown in the time that the Constitution was written. They did not think about life that way. They did not conceive of personal relationships in the same way that we do to a great extent. So the idea of privacy that we have would have been something strange and different to them, something that they were not familiar with or used to. The court went so far to say that we can draw this right from a penumbra of rights in the Bill of Rights. Now, a penumbra is an interesting word. It's usually, and up until this point, had been used as a scientific word. And to the best of my understanding, if you think of when there is a solar eclipse, a total solar eclipse where the circle of the sun is blocked out, shadowed by the moon, but yet you have the corona, you have this rays of light still coming out that you can see in stark contrast to the dark circle of the moon shading the sun. That is the idea of the penumbra. It's something that emanates from something else. Again, in science, has to do with light and light theory and how light works. And it's the idea that there is a core something, and it is giving out light. It is shedding its light to the universe. So basically they're saying here, we don't have the words. We don't have the background for this, but if we take the Bill of Rights and the Fourth and Fifth Amendment and the 14th Amendment and put them all together, they emanate this idea that there is a fundamental right to privacy that is enforceable and that has constitutional ramifications, that states have to tread very lightly here, or otherwise they are violating a citizen's constitutional rights. One of the biggest issues, however, that they run into in the case is the idea that by its very nature, the idea of obtaining an abortion is not solely between the woman and her physician. The end result of an abortion is that another being will not come into being, will not be born, will not come into their status as a citizen, as a member of society. Um, and it is very clear throughout English history going back to the Dark Ages, uh, infanticide is illegal. Children are protected and have certain rights, that the state is seen as a protector of children, even if their parents do not. Um, and the state of Texas, because in Roe v. Wade, it was basically Miss Roe was a woman wanting to obtain an abortion and could not because Texas laws prohibited her from doing so. And Wade was one of the health directors of the state of Texas who uh, had apparent authority to enforce these laws and these rules upon doctors and medical facilities and basically forbid them from performing abortions. Um, the state of Texas, in their arguments, and I don't think irrationally so, claimed that they had a role here, that part of what they were doing here was trying to protect children, trying to protect the unborn child, and that there were certain rights that attached to the unborn child, and that the state had a definitive interest here, and that in their police powers, again, to ensure the health, safety, welfare, and education of their people, that could include the unborn at some point. The court really struggled with this, and for good reason. Um, Although common law never really stated when a child, when a child became a child, when a fetus or an embryo became a child or a citizen, there were some kind of auxiliary type laws, such as if you injured a pregnant woman and as a result her unborn child was injured or died, you could be held for civil damages. The court recognized that there was a potential life, and you could be sued in even in the English common law courts to pay the damages that would be attributed as the result of the loss of the life of that child who had not been born, that potential child. So there were recognized exceptions in English law that if a father left an estate, died, and then a child was born within 9 months of the death, who could be attributed to be, purported to be his child, that the child had rights, that the fact that the child existed and was conceived by the father before death gave the child the same rights as the siblings that had been born before the father died, or even if there were no siblings, gave this child the rights of inheritance, and that would include property and the titles and benefits that the father would have had in society. So it was not an irrational position for the state of Texas to take and say, wait a minute, we have some say here, historically, from the common law, from our statutes, from our regulation of medical procedures and practices. You can't just shut us out and say, oh, we don't belong here at all. That there is some role for the state to play in this process. Because of that, the court had to really struggle with how they were going to deal with this. And they came up with an idea, which, again, I don't know how much basis it has in medical science. Unfortunately, I am not a scientifically oriented person, and my medical expertise is zero to none. But my understanding from reading the law on this and reading analysis of the case and of the subsequent cases is that the court kind of made a decision here on how they're going to treat this without really looking at the medical reality of what's going on during a pregnancy. And the court basically said, the judge who wrote the decision said that we're going to break pregnancy into three parts. Now, a normal human pregnancy gestation period is approximately 9 months. And so they said, we're going to break it into trimesters, which very quickly in everyday language came to mean, well, the first 3 months, the second 3 months, and the last 3 months. And in doing so, the court recognized the fact that there are competing interests here, that there is the woman's right to privacy, the woman's right to deal with her doctor to seek a medical procedure, versus the state's right to control health, safety, and welfare not only of the mother but of the unborn child, unborn fetus that exists in some way but is not recognized as a person. Now, the court was very clear to state that a fetus or an unborn child is not a person under the definition of the 14th Amendment. Because had they allowed that idea to enter, then they would have been in very deep trouble, because far from the state being able to say, well, we think we have a right, we think we have an interest here to be involved, if we declare an unborn fetus to be a person, then under the 14th Amendment, under any rational definition of the 14th Amendment, you would say that the state not only has a right to be involved, but the state has a duty to protect and to ensure the safety of that unborn person. And then it becomes a question of, well, whose rights take precedence, the mother's or the fetuses? But they will both have the right to be protected and have the power of the state come in to enforce that protection. So the court made it very clear, we're not calling a fetus a person. It is not. However, we do recognize the fact that a pregnancy, given its normal course, if the mother is healthy and the fetus is healthy, will produce a person, will produce a child at some point, and therefore the state does have some interests involved here. So using this idea of a trimester, the court basically came out and said that in the first 3 months, the first 90 days, this whole issue is between the woman and her doctor, that whatever is happening within her is not significant enough, not close enough to being a person as defined under the 14th Amendment of the Constitution for the state to have any issues or to be involved, and it's between the woman and her doctor to determine whether she will have an abortion or not. In the second trimester, they said that, so the third to sixth month, or the fourth to sixth month, the court said that the state begins to have an interest, although somewhat limited, and that they can apply certain regulations and certain controls on the procedure, but they can't outright prohibit it, and certainly they cannot prohibit it if the life of the mother is in danger. In the last 3 months, so month 7 through 9, the court recognized the state's authority and power to have some control and say here, and said that short of anything that would endanger the life of the mother, the state had the right to issue regulations and to control what's happening here. That is a basic reality. Now, because of the way that stare decisis and precedent work, once the court came down with this decision, there are actually two cases. Roe v. Wade is a more famous one, but there was another one, Doe versus Bolton, that was handed down the same day, also dealing with abortion. And in effect, through this, the court had struck down the existing abortion laws of 2 states, one of them being Texas, a very large and fairly heavily populated state. It became immediately clear to all the other states that still had anti-abortion laws that they were now illegal, and that they would have to scramble to somehow deal with this new thing, because once the court has declared that there is a constitutional right, and that it applies to the states, and the states must honor it in dealing with citizens, the only real way to undo that is to have a court decision that would overrule, which, again, in terms of precedent and stare decisis, is not likely to happen, at least not while the same judges are sitting on the court, or to amend the Constitution. And already by 1973, the political parties in this country had begun the process that now is nearly complete of splitting between themselves over ideology and over what they thought the future would be, over how they thought laws should be administrated, what they thought to be the purpose and rightful place of government. The divisions that we see today had already begun in 1973. So the reality of somehow enacting any type of constitutional amendment to overcome what the court had done here either to make abortion more restrictive or to make it more available, because Roe v. Wade didn't make it entirely, completely available. And initially afterwards, I probably would say it wasn't quite as available as it is today. Um, but the idea of trying to somehow change it in either direction by a constitutional amendment just was not going to work. It has been tried a number of times, and it has never gotten anywhere. It's never even gotten out of the Congress to present anything to the states. The case has become one of the most hotly contested cases in American history. We are now coming up on 50 years since it was handed down. There's still a great deal of controversy. There are still people vehemently, radically dug in on each side of this issue. It is still comes up in every election, in every political campaign, anything to do with the federal government, and even with the state legislatures and state governors. What is their position on abortion? Far from, and it's kind of interesting because with many things that the Supreme Court does that may be initially unpopular, such as Brown versus the Board of Education, where they determined that public schools have to be segregated. Initially, there was a great deal of resistance to it, but that resistance gradually, and with some help from the rest of the civil rights movement, it gradually faded away, and we reached a point where I would say the vast majority of people in the country today accept Brown versus Board of Education as the basis of our legal system and our educational system, and they have no issue with it. So the matter resolved itself not only in the law, but even in popular perception to a great deal. Abortion is not so. Abortion remains very, very divisive subject. The people's views on abortion, when you get away from an abortion to save the life of the mother, it's still dramatically split. It varies from time to time, depending whether the country's in a more conservative or more liberal mood. It varies between 50-50 to 40-60, 60-40, but there is no, as of yet, clear consensus as to what should happen with Roe v. Wade. And of course, this is the reason why the upcoming nomination and confirmation process for someone to replace Ruth Bader Ginsburg is so contentious. I believe it is probably the primary reason why the confirmation process of Justice Kavanaugh was so contentious, is that with Trump in the White House taking a conservative stance on this issue, he is looking for conservative judges who would be inclined to limit abortion rights or to possibly even at some point overturn Roe v. Wade. And that has become such a hot button issue for the liberals and the Democrats. They will fight tooth and nail to make sure that that does not happen. Again, I don't see any immediate resolution of this. When Trump became president and when the Republicans gained greater control of the Senate in 2018, and it became clear that they could basically nominate and appoint whatever judges they wanted, a number of states, Rhode Island and New York among them, amended their abortion laws to make them even more liberal than they had been, basically on the idea saying to their people that, well, even if the Supreme Court overthrows Roe v. Wade, in reality, probably all that's going to do is say that it goes back to the states again, that there's no longer a federal constitutional right, and the states are free to legislate as they would wish in this area. And therefore, a number of the liberal states took steps to enact statutes that if Roe v. Wade were to be overturned, basically the availability of abortion would be as free, maybe even freer than it is now under the present regime, under the present constitutional framework. So it's not as if, should Roe v. Wade be overturned, that the right to abortion would disappear overnight. What would happen is in a number of conservative states, such as Texas and Louisiana and Arkansas, there probably would be movements to curtail abortion or possibly make it illegal so that for women in those states it would become an issue in terms of the availability of abortion. But it probably, I can't see where nationwide that would happen. Now, again, there is also the possibility that a more conservative court could find that an unborn child at some point during gestation is a person under the 14th Amendment. And when that happens, then all bets would be off, because if they were to make a move in that direction, then under the 14th Amendment, states would be required to give protection to the unborn at a certain point in time or to a certain extent. So there is, I suppose, the outside chance that that could happen, which would call the right to have an abortion into jeopardy into all 50 states and all the territories. But that's kind of an outside thing. And one of the things we see, even as more conservative judges have been placed on the court over the last few years, both through President Bush II and through Trump, one of the realities is that conservative judges tend to be very much adherents to the idea of precedent and to the rule of stare decisis. They're very loath to just come out and directly overturn a case. So you have some interesting things. And again, one of the legal fictions that we deal with is that if the present sitting justices don't like a prior decision, they may not come right out and throw it out, but they can start working away at it over time by making exceptions, by finding, well, in this particular area, we don't think the case exactly applies. We're going to rule a little bit differently. And of course, if you make 500 exceptions to a rule over a period of 30 years, you get to the point where the rule is pretty much gone, and some court at that point might have no problem saying, there are so many holes in this rule, it's all over, let's just put it to bed, let's knock it down, throw some dirt on it, it's done. Conceivably, that could happen here, although with the popular sentiment that exists in the country today, I would find that difficult to believe that the court would go that way. So it's very interesting. Judge Barrett, who's has been nominated by the president. If you read her writings, even though she purports to be a conservative Catholic, which would mean that she would be on a religious moral level opposed to abortions, in her writings as a professor and even as a judge, she has very much said that she upholds the idea of precedent and stare decisis, and she also says that her religious beliefs should not be how cases are decided, that she is bound by the law and by precedent in how she would decide a case and write a decision. So even here, even with somebody who morally and religiously may be dramatically opposed to abortion, as a conservative, as a judge who looks back, and she has said this, she is a constitutionalist in the sense of she looks back to how the Constitution was written and what did the writers of it intend 200 and some years ago, and that's how it should be interpreted. They're not going to be running up and down and right and left overturning cases just because their own personal beliefs happen to go that way. Regardless, we're in for an interesting confirmation process. We're in for an interesting time the next few years as the court comes to grips to try and deal with these issues. But I don't think Roe v. Wade is going anywhere dramatically anytime soon. Even with the number of conservative justices that are now on the courts.